In India, arbitration is governed by the Arbitration and Conciliation Act, 1996, which is based on the UNCITRAL Model Law on International Commercial Arbitration. Here's how arbitration works in India. Agreement to arbitrate. Just like in other jurisdictions, arbitration in India begins with the parties agreeing to resolve their disputes through arbitration. This agreement can be part of a contract, a separate arbitration agreement, or entered into after a dispute arises. Arbitrator appointment. If the parties have not already specified the number of arbitrators and the method for their appointment, the default rule is to have 3 arbitrators. Each party typically appoints 1 arbitrator, and the 2 party appointed arbitrators together choose the 3rd presiding arbitrator. Arbitration procedure. The parties may agree on the arbitration rules and procedure that will govern the arbitration. If they haven't agreed, the arbitrators will conduct the arbitration in a manner they consider appropriate. Challenging an arbitrator. In India, there are provisions for challenging the appointment of an arbitrator if there are doubts about their independence or impartiality. Arbitration hearing. Similar to other jurisdictions, an arbitration hearing is conducted, during which the parties present their case, evidence, and arguments before the arbitrators. Time limit for award. The arbitrators are required to make their award within a specified time frame, which is typically 12 months from the date they receive all the necessary documents and submissions. Confidentiality. While the Indian Arbitration Act does not specifically address confidentiality, parties can agree to keep the proceedings confidential. However, Indian courts have recognized the principle of confidentiality in certain cases. Enforcement of award. Once the arbitrators make their award, it is final and binding on the parties. If a party fails to comply voluntarily, the other party can seek enforcement of the award through the courts. Indian courts generally respect and enforce arbitration awards. Appeals. Under Indian law, there is a limited scope for challenging an arbitration award. An award can only be set aside by a court under certain circumstances, such as if the arbitration agreement is invalid or the award is in conflict with public policy. International arbitration. India also recognizes and enforces international arbitration awards under the New York Convention, allowing parties to enforce foreign arbitral awards in India and vice versa. It's important to note that while arbitration is generally less formal and more flexible than court litigation, the process and outcome can still have significant legal implications. Parties should carefully consider their rights and obligations when entering into an arbitration agreement and should seek legal advice if needed. Thank you for watching. Please like, share and subscribe for more.